Welcome, Lisa, to the microphone.
Okay, I guess I'm picking up from Michael's story of what happens when you've gone through that nice process of exchanging position papers, responses on position papers, and hey, what? The Commissioner doesn't change his mind and you're issued with an amended assessment. So where do you go to from that point? There are 3 points I want you to take away from this morning, and they are: you are guilty under the Tax Act until you prove your own innocence. The taxpayer bears the onus of proof. You have to prove everything, the Commissioner has to prove nothing. There is no evidence, like contemporaneous evidence, in discharging that onus of proof. I'll go through in a little bit more detail later why this is such a heavy burden in practice and the practical implications that flow from it. And under the federal court rules, the tax list directions operate like a rocket docket. Once you're in court, it moves very, very quickly, which means all your preparation for your tax dispute needs to take place before you even file your application. Some procedural points. An amended assessment is conclusive evidence, except in Part 4C proceedings. That means that to challenge an amended assessment means you're basically confined to a Part 4C appeal. Things like judicial review, although the Commissioner is exercising administrative powers, don't work because of the conclusive evidence rule. The exceptions are for general interest charge and shortfall interest charge, which do not form technically part of an amended assessment. So you can use judicial review, Section 39B of the Judiciary Act, to challenge the imposition of GIC and SIC. Merely lodging an objection is not a basis for deferring legal recovery. Because that amended assessment is conclusive evidence, the Commissioner can rock up to court and sue on it, even though you've technically lodged an objection. There are practices and procedures around when the Commissioner will seek to recover once you've lodged an objection, and generally those depend, as Michael was saying, on the Commissioner's view of risk to recovery. The Part 4C process, when I say Part 4C, I'm referring to Part 4C of the Taxation Administration Act. It begins with the lodgement of an objection. If you've received an amended assessment, you have 60 days to lodge an objection. An objection takes a prescribed form. There's a form you'll find on the ATO website. It's a requirement for a valid objection to state your grounds fully and in detail. But you need to be aware that under the Taxation Administration Act, a taxpayer is confined in their appeal to the grounds set out in that objection unless you get leave of the court to amend. So generally what happens is your grounds in your objection tend to be fairly general. So this, for example, I'm disputing this amended assessment because the amount of $60 is in fact deductible under Section 8.1 because it was incurred by me in deriving my assessable income. So you tend to have fairly generic grounds because you don't want to confine yourself and then find you need leave to amend. What's involved in the objection process? Well, you lodge your objection and under ATO procedure, somebody other than the auditor will deal with that objection. So it's intended, in theory, to be an independent review. 9 times out of 10, the tax office have a habit of agreeing with itself. So they will say, oh, guess what, we were right. But it is possible that the Commissioner may change his mind on the basis on which he's issued an assessment. And one of the things that might happen is that you can get a Part 4A determination made against you at the objection stage, even though it wasn't made against you at the assessment stage, in which case you will need leave to go and amend your grounds of objection when you get to court because you didn't object on that ground because it wasn't there before you when you lodged your objection. Surprisingly enough, you will get that leave. Part of the objection process can involve the Commissioner asking you for further information. the Commissioner can ask for further information within 60 days. You then respond, and the Commissioner then has another 60 days in which to issue his notice of objection. And oftentimes it takes longer than that 60 days. Section 14 ZYA of the Taxation Administration Act allows you to force the Commissioner to make a decision. Now, there are upsides and downsides in issuing such a request. If you are ready to go, i.e. you're ready to proceed with your appeal, you may consider it to be in your interest to just bring the matter on. If you're not ready to go and you pull the trigger, you actually might find that you're in a worse position than if you just let the matter roll on. And sometimes letting the matter roll on might result in the Commissioner changing his mind, depending on what sort of information is asked for and depending on how much information you can provide. Burden of proof. This is the guilty until proven innocent point. Section 14 ZZO, the Taxation Administration Act, imposes upon the taxpayer the burden of demonstrating that their assessment is excessive. It's a really heavy burden. And it's a heavy burden because tax disputes are old disputes. 9 times out of 10, when you're litigating with the Commissioner, you're not litigating a transaction that happened last week, last year, even 2 years ago. Sometimes these transactions may have taken place up to 6 years ago. And in the meantime, what happens is witnesses die. You may have had a falling out with a witness, so somebody who worked for you, who knew about the matter, may have left on bad terms in the meantime and may not be willing to make the time necessary to assist you. Records go missing. Your auditors can go out of business. This happened a lot with Arthur Anderson. When Arthur Anderson went under, a huge number of audit records went missing. And your record retention policy becomes very important. I've had cases where clients have said to me, but I'm a small business or I'm a private company and I don't keep the same level of records as you might expect in a large corporate. Well, you can make that argument to a judge, but they're not going to listen because they'll say that's all very well and good and it's really nice, but it ain't relevant. You bear the onus and you've got to discharge it. The best time to prepare your case is when you undertake your transaction. So my strongest recommendation to people is make sure that you keep the right records when you're undertaking your transaction, because your contemporaneous records are always going to carry more weight than somebody's recollection of them 6 years down the track. The other tricky bit in tax disputes arises in Part 4A, the anti-avoidance rules. Part of the anti-avoidance rule is the concept of a tax benefit, and a tax benefit arises where it might reasonably have been expected that you would have obtained the tax benefit as a result of a scheme. Now, proving a hypothetical, proving something that you didn't do but hypothetically could have done by reference to contemporaneous records is a really tricky thing to do. But being aware of the existence of Part 4A and being aware of your obligation to keep records can assist you in discharging that onus. Avenues of appeal. You have 60 days to appeal once you receive a notice of a decision on objection, and that is a drop-dead date. If you miss that date, you have to notify your insurer because you cannot get an extension on it. The choice you have to make about your appeal is, where do you appeal? Do I go to the federal court or do I go to the AAT? The reasons you might choose one avenue over another will completely depend on the case before you. An AAT appeal is different from a federal court appeal because the AAT will stand in the shoes of the Commissioner and re-exercise a discretion, whereas the federal court is a review proceeding. It's looking for errors of the decision and will remit the matter back to the Commissioner to make the decision in accordance with its reasons. For things like penalties, you might be better off going to the AAT because they will re-exercise the Commissioner's discretion. Costs are often an issue. Sometimes, most times, it could be cheaper to go to the AAT. But if you've got a matter that's likely to go on appeal and there's a significant amount at stake, the AAT may just actually add another layer in your appeal proceedings, so you'll end up in the federal court anyway, so why bother? There's a different level of formality. The AAT is a much more informal forum, and the nature of the decision maker. Oftentimes, there are some very good AAT members who know a lot of tax, and there are some AAT members who don't know a lot of tax. So it depends. It depends on the nature of your dispute. It depends on the amount involved. If the amount's not high and there's no massive principle at stake, you can be better off at the AAT because you might find that the Commissioner might be more willing to settle in an AAT-type environment. Going to the federal court now. Federal court process. Tax appeals are governed by their own order, which is Order 52B of the Federal Court Rules. The process commences with an application form, and you have to file a tax list questionnaire. The tax list questionnaire gives the judge an idea of the amount in dispute, whether there are related proceedings, how long the dispute has gone on for. Is this a result of an audit, in which case the Commissioner should have the information he requires, so they take a different approach to things like discovery. Tax matters are directed by a tax list coordinating judge who will sit down and work out how your appeal relates to other proceedings that are in court. Once you file your application form, the next step is an exchange of appeal statements. The Commissioner generally goes first, and the appeal statement is basically to set out the basic elements of the case. So what are the facts? What are the facts in issue? What facts are agreed? What are the legal issues? And what are the contentions of the parties? The Commissioner files his statement 28 days after you file your application, and your appeal statement is due 40 days after the appeal statement. Those deadlines are strict. If you don't meet them, particularly in Melbourne, you'll find yourself in trouble. The next step is a scheduling conference. When you file your application, you are allocated a scheduling conference date. It's brought before the judge. Counsel is expected to attend the scheduling conference. At that scheduling conference, the judge is trying to ascertain what are the facts in issue, or what facts are agreed, what are the legal issues in dispute, and how is this matter going to actually run. So you have to be in a position to name your witnesses, describe the content of what those witnesses are going to talk about, and your pre-trial timetable is set. And those timetables, the rocket docket, are really fast. So you'll be lucky in Melbourne to get 8 weeks to file your affidavits. You'll get a trial date within 12 months of the scheduling conference. The commitment by the Federal Court in putting this tax list procedure in place was, we're going to be harsh on you to get the matter up, but we will endeavour to get these matters heard quickly, and we will endeavour to get our decisions out quickly. If you fail to name your witnesses, or you can't tell the judge what they're going to talk about, you're likely to get into trouble, and your trouble may take the form of, okay, I won't give you 8 weeks to file your affidavits, I'll give you 4. Which is why it's so important that your case is ready before you step into court. You need to know how you're going to prove and what you need to prove. Under the tax list directions, the courts will provide only limited discovery. Generally, taxpayers don't get discovery from the Commissioner simply because it's not relevant to their case. The onus is on you to prove your position. What the Commissioner thinks and what papers the Commissioner has generally aren't relevant to that unless he's obtained documents from parties that you don't have access to. Under the rules, to minimise interlocutory disputes, you cannot get particulars unless you demonstrate a real need for them, and you have to do that at the scheduling conference. And the reason they brought these processes in place was there was getting a point where tax cases were being caught up in long interlocutory disputes. I think you'll find, if you look through the law reports, there was a dispute between the Commissioner and Rio Tinto, which got so bogged down in interlocutory disputes over particulars and providing documents. The case never proceeded to trial, but to avoid these long interlocutory disputes and people trying to get strategic advantages over nothing, the federal court said no. Tax cases are about substantive issues, and we're not going to let these matters get bogged down in a whole lot of posturing about things that in the end don't really matter. So the practical implication of the process is it's a front-loaded process. Be ready before you step in there. Know your case. Know your evidence. Make sure you have your evidence. Know your witnesses. Speak to them. Make sure you know what they're generally going to say, even if you haven't got your affidavit sorted before you file. In the ideal world, you'll have all of that lined up before you even get to court. Because it is a front-loaded process, it means a lot of the work is done before your proceedings commence. And that means that oftentimes the best time to negotiate a settlement with the Commissioner is after he sees your evidence. But by that stage, you have incurred a lot of your costs. It may mean that settling tax cases under this sort of system is actually expensive in the sense that you'll have burnt costs because you have to do all of this preparation to get your case to settle. And that's maybe something that you need to explain to clients so they understand, because it used to be a case, well, this matter is going to settle, so I don't really want to spend the money on my counsel speaking to witnesses, I don't want to spend money on my lawyers undertaking a review of documents. It'll settle. Well, unfortunately, now to get matters to settle, you often have to burn those costs. Just leave the matter open for questions now. Thank you.
Any questions?
Neil Brown, this is a question I suppose to both. If you could, I'm just curious about, shall I sit down or stand up? On the Taxation Commissioner's power to deferral or instalment, so I was very interested in that, and the criteria that the Commissioner can use for rejecting that request. One in particular that took my fancy was the suggestion, I think, if I remember correctly, was where you can go and borrow the money from a friend or from a family, from your family. Most courts in analogous situations would regard that as capricious and harassment, of course, depending on the facts. And I wasn't quite clear whether that is reviewable, and for that matter, whether the whole policy is reviewable.
The answer on the question of review is no, it's not stickable. It's a discretion of the Commissioner. It's very difficult to review. To review it would mean bringing proceedings under Section 39B of the Judiciary Act. I'm not aware of any successful case. The Commissioner is concerned about the risk to the revenue. The more that you can show that you've attempted or to raise the funds to pay it, the better the position you're in. The Commissioner does want to make extensive inquiries. You will understand the Commissioner is concerned about divestment of assets as much as people having assets, particularly where the argument is that taxpayer doesn't have the capacity to pay. It's really about what security can be granted, if it's going to be paid over time, how will it be paid over time, and the extent to which taxpayers have gone to the trouble to find the money to pay the Commissioner, and indeed the circumstance in which the assessment has come about. If it's a tax scheme case, you'll find that it's dealt with quite differently to if you have a technical argument over the application of Part 4A to a transaction that was entered into in good faith. All those matters will be taken into account.
But no one has tried to review the policy itself.
No, look, it's an extremely difficult thing to do because the powers are vested in the Commissioner to grant extensions of time to pay tax. There is a case under the old Section 206, it was about 1994 decision of Justice O'Brien, where he actually held that the power of the Commissioner to determine when and how tax should be paid in instalments prevailed over the Judgment Debt Recovery Act. So it is a very difficult thing to challenge.
Thank you for your attendance this morning. I hope that what was said will have done more than confuse you. A huge topic that was covered in a very short time. Could we thank Lisa and Michael for all the work they've done? I thought that what they've said has been, as I said, of great, wide-ranging and very sensible comments that they've made. Thank you.